Hi, this is Greg Laquan, and it's my honor today to introduce Chief Justice Mark Recktenwald, who served on the Hawaii Supreme Court for 15 years, retiring as Chief Justice back in October of 2025. This is a gentleman who needs very little introduction, but I do want to make a few comments about his storied term as a justice on the Hawaii Supreme Court. Chief Justice Recktenwald was instrumental in modernizing the filing of pleadings in the circuit courts in the state of Hawaii and also in the appellate courts by instituting electronic filing. During the COVID era, he instituted Zoom hearings so that the wheels of justice could continue turning. And one of the most remarkable things that drew my attention to his work as Chief Justice was in 2012, he instituted a program called something in the nature of, and you can correct me if I'm wrong, but courts in the classroom. It's actually in the gymnasiums where 6,800 Hawaii youth were exposed to the workings of our judicial system. And he also was very active in promoting access to justice, elevating Hawaii's status to number 6 in the nation. And since retiring, he has been active in an organization of and you might correct me on this if I'm wrong as well, of retired chief justices of state courts seeking to restore trust in government and promoting and preserving the rule of law. Without further ado, Chief Justice Mark Recktenwald.
Thank you very much for having me. Good afternoon. Aloha, everybody. I'm very excited to be here and excited to be talking about this topic. It's something that's occupied a lot of my time since I retired, and I'm hoping today to be able to share some of my own experiences in responding to what I saw as challenges to the rule of law, provide some updates on what's happening nationally on that front, offer some suggestions for those of you who might be considering becoming involved yourself, and then answer questions. I want to thank Greg and the section for having me here. Say aloha to everybody out there who's watching remotely. I want to thank Kathy Betts for her wonderful service as Executive Director. Can you please join me in acknowledging Kathy? So I just want to start by making clear I'm not here to advocate for any candidate or against any candidate or against any political party. My views are not necessarily those of the HSBA. Even though I'm no longer bound by the Code of Judicial Conduct, the work I'm doing that you're going to hear about is still nonpartisan with the Alliance of Former Chief Justices. So I'm not here to advocate for anyone to vote for or against any. But I am going to talk about the rule of law, and I'm going to identify particular initiatives or actions or statements that I think are problematic. So I'll start by asking what the rule of law is, identify some ways in which I think, in my view, it's been threatened. And, you know, it's interesting. You'd think it's a very simple concept. There's actually a lot of different definitions. I've seen definitions that were 3 pages long, which I think is maybe a little bit too long. But this is a definition I gave. There was a group of high school students came into the Richardson School of Law to spend a week sort of learning about the law and doing a mock trial, meeting a lot of folks in the community. I spoke to them, and this is what I told them. First of all, I said, it's kind of a fancy sounding term. And by the way, it doesn't poll well among people. Folks in the community don't really get what it means. And I think for those who are trying to advocate for it, you have to put it in more tangible terms or in a way that folks can relate to their own lives. I think we're a society governed by rules, not by the whims of whoever happens to be in power. Those rules apply equally to everyone, rich or poor, popular or hated. The rules are clear and understandable, ideally, and everyone gets treated fairly, including with a fair process. I gave them some examples of how I believe the rule of law is being threatened. And, you know, it's very interesting, you know, how you define this and how you come at it. I think there could be different views. You know, reasonable people could think differently about whether a particular policy or action imperils the rule of law or not. There's the one that for me I think I felt very strongly about, and because it was a systemic risk or a challenge to the rule of law, was threatening lawyers with punishment for who they represent or what positions they take or who they associate with. And that, of course, is the executive orders from last spring. That was, for me, an event that caused me to focus in with a lot more precision on what was taking place. And maybe there are folks here who feel like, hey, that's a political point of view, and we can have a conversation about that. But that for me, I thought was sort of a bottom line that we all could agree on, and I'll explain why in a minute. Judges being personally vilified and threatened with impeachment for how they rule. That was another example that came up last year. And I think that's, of course, relates to federal judges who have life tenure, and CJ Roberts very quickly when the first one of those comments was made by the president regarding Judge Boasberg in the District of Columbia, who had ruled regarding the deportation of individuals to El Salvador. So this is very early. There were planes on the tarmac, supposedly in Texas. The planes took off. The people were deported, and there was a lot of discussion about whether the government lawyer in the courtroom knew or didn't know that that was going to happen, and what he or she had whether that he had misrepresented something to the court. And immediately, I think that within a few days of a ruling by Judge Boasberg, who suggested he did what happened is very problematic, the president called him, I think it was a left-wing radical, Barack Hussein Obama appointee, and very, very personal criticism. And Chief Justice Roberts, very quickly later that day, and without referring to the president, explicitly said that the appropriate path for someone who thinks a federal judge has ruled incorrectly is appeal. And he issued that statement, and that was important for me too, because that kind of indicated, well, the Chief Justice of the United States Supreme Court realized that in some circumstances a response is appropriate, even from a sitting judge. So that mattered to me. And then the last thing that I'm going to talk about, and again, I'm very interested in folks' views. And again, this one is, some folks may agree, some may disagree. I think that having people targeted with or threatened for government retribution for speaking their mind or exercising their rights for free speech is very corrosive to our democracy. So I would view the three things I've just identified as being systemic challenges to the ability of our democracy to function and our legal system to function, rather than policy debates that anyone could have, and you might feel one way or the other about tariffs, but whether talking about the fact that law firms are going to be sanctioned and their members are not going to be allowed on federal government premises, and people they represent might suffer contract consequences if they do business with the government. Those things, I think, undercut the system of justice. So bottom line, I think lawyers need to be able to do their job and represent whoever needs it. And judges have to be able to call it like they see it. And people have to be able to have free and fair debate without fear of their government punishing them for that debate. I'll just very briefly talk about the work of when I was on the court. We did a lot of projects and endeavors that I think were designed to build up public trust and confidence in the court and in the rule of law. Greg mentioned courts in the community, which I think is singularly important, because during the course of 10 years or so, I guess it was even a little more than that, but close to 15, we went out typically 2 times a year and did oral arguments in real cases at high schools across the country. So I think that was a very, very important initiative. And some of the others are maybe not as intuitively obvious, but we instituted online filing so people can access our records and see what we're doing online. We've live streamed oral arguments both in my court and in trial courts. We've done a lot to reach out to the bar and the public, especially through the PACE Commission, which Justice Ganoza chairs. It's explicitly tasked with increasing public understanding of government in general and the courts, and targeted particularly at young people. So that's sort of what we were doing. It's not like the notion that we need to help people understand or have people understand who we are and what we do, try to demystify it and have people understand the nature of the process that we follow as being one that's worthy of their respect. These are thoughts that we had and tried to implement for many, many years before President Trump's second term. Now, things, of course, changed in 2025 when the president took office for the second time. There was a, pick your metaphor, avalanche, tidal wave of executive orders from the administration. Many of them, I think it's fair to say, challenged what were considered to be settled assumptions about our legal system. Again, one might disagree, might say, well, your settled assumption is one that I personally disagree with. And I understand that, but there was a whole lot came out really quickly. And I think, certainly got everyone's attention. I think we could all agree on that. In one area in particular, there were a lot of initial executive orders talked about, efforts by various entities, employers, and the like to have more diverse workforces that were welcoming to folks from all backgrounds and all points of view. And there was a lot about that in the early EOs. And so one of the things my court decided to do was to issue a statement that sort of reaffirmed our commitment to increasing access to justice, making sure that everyone was welcome in our courts, whatever their circumstances, eliminated bias within our institution, collaborated with the community. We rejected the notion that efforts to welcome people into our courtroom, to support members of our workforce, could be characterized as somehow inconsistent with our nation's civil rights laws. And that was something we did as a court. One other court did that, the New Mexico Supreme Court. And I think it was our way, and I think it was very carefully and temperately worded, but it was one way of expressing the view that we are going to stand up for the rule of law and for access to the courts and due process. I issued it a short time later, or actually it might have been just before. I thought it was later, but I think it might have been a day before. There was an executive order that talked about English as a first language of our nation. And of course, here in Hawaii, we have two official languages. We have the Olelo Hawaii, and we have the English language recognized as co-equal, I think, in effect in our Constitution. And so I put out this statement to reaffirm that respect for Olelo Hawaii and allowing people to engage with the courts in Olelo Hawaii was something that we would continue to value and not back away from. It was around this time that the first EOs that challenged law firms began to come out. And again, I mentioned earlier, if they took on clients that were disfavored by the administration, made arguments that were disfavored, had diversity, equity, and inclusion programs, or welcomed certain attorneys, that was viewed as grounds for sanctions. So this is the EO from Paul Weiss. There were, of course, a number of firms, large, powerful firms, who were targeted with these EOs. I just put it up here so folks could see sort of the recital of the things that had been viewed as problematic. Who you represent, who's part of your firm, what kind of arguments you're making were identified as problematic. As I think many of you know, within a week, Paul Weiss settled with the federal government or with the administration. That was a subject of a New York Times article on Sunday. I don't know if folks saw it, but that sort of explained the thought process behind the firm agreeing to the various things that are referred to in the subsequent executive order, backing off from diversity, equity, and inclusion, disavowing the work of one of their former partners, agreed to policy changes, of political neutrality, and notably dedicating the equivalent of $40 million in pro bono legal services to causes that the administration favored. Now, these aren't bad causes. I mean, but they're the causes that the administration thought that Paul Weiss should donate this kind of very, very substantial amount of money to. So just a couple of things, what is the impact? Why was this of such concern? Well, we have an adversarial system. We need lawyers willing to take on unpopular cases. We need lawyers willing to make arguments that might not be palatable to the current administration, but if they have a good faith basis under Rule 11 and they're in their client's interests, firms or individual lawyers shouldn't hesitate from making those arguments. And so it really has, to me, it has a systemic, potentially systemic impact. So as I think everyone knows, there were 4 firms that fought against the EOs, and they prevailed uniformly. I think I have a slide here from. No, this is it. No, I'm sorry. No, there you go. So this is a summary judgment motion that Judge Beryl Howell granted in the District of Columbia Court, in which she very forcefully said that the executive orders were unlawful. Suggested this is sort of Shakespearean. The first thing we do is kill all the lawyers, and very colorful language. I think uniformly the EOs were found to be invalid. Uniformly, the 4 firms were validated in refusing to in their challenge to the EOs. It's now pending before the DC Circuit. I think it's worth asking, are there concerns, even though the sort of uniform the uniform holding of the courts have been to say that the EOs were unlawful and improper. What is their broader effect, and what effect has there been on for example, the pro bono policies of large national firms? Are they self-censoring? Are they passing on clients or cases they might have taken a few years ago? It's kind of a complex subject because the firms are not necessarily terribly transparent about what work they're doing, but I think at least from what I've seen, and I'm open to anyone else who has thoughts about this, it seems like the work has been certainly a different type of work was being done. Maybe the overall number of hours being billed was not sharply down, but the types of cases that were being taken on, I think, is pretty clearly firms were backing off of cases that would be involved suing the administration or defending against actions of the administration. So I do think it had a real self-censoring effect, which I think is, again, very problematic from a viewpoint of a former judge. You have an adversarial system. You need frankly good lawyers to be able to advocate very difficult cases. And if they're backing off at taking those cases, I think that's problematic for the system. One quick question, so what to do about this aside from the lawsuits that are coming through? And there is something out there that I wanted to share, and this is kind of very recent news. So the organization, and I'll get into it in a minute, the groups that I've been working with, but the group that supports the work of the Alliance of Former Chief Justices is a nonprofit, nonpartisan organization called Keep Our Republic. So they provide us with administrative support. They've done a lot of work around election integrity, around building capacity and trust in the electoral process in about 4 different battleground states. I think Pennsylvania, Michigan, blanking on the other, I think they're in North Carolina. So they've gone to a number of these states, engaged with election officials, try to find out how they could be supported, also try to get them out in their communities, explaining, hey, this is what the electoral process is like. This is what we do. You can come to our voting center and get a sense. We will walk you through and show you as a way to sort of develop trust and confidence in those processes. So Keep Our Republic, about a year ago, began, I think, recognizing that a part of this notion of trying to have an electoral process that will work and function is also having respect for the courts, because all of these disputes, certainly in 2020, I think 60 plus of them ended up in the courts, and that's quite a likely outcome going forward. So it began working with former federal judges, something called the Article 3 Coalition, and then the Alliance of Former Chief Justices, to build confidence and understanding in the rule of law. And what I have here is something called the Principles for the Independence of the Legal Profession. It's basically, I'll say it's an aspirational pledge, although it's written fairly strongly, that basically it's a pledge to stand up to the kinds of demands that were being made in the executive orders. That's the way I read it. So we're going to represent who we believe. We're going to recognize that people are entitled to counsel, whether that's popular or not with folks in power. We're going to make arguments whether or not they're popular with folks in power. We're going to associate with lawyers who may not be on the good list of folks who are in power. And those are things we're going to do as lawyers. And we are going to, I think there was also a commitment to just look, generally speaking, the Bill of Rights and respecting the ability of people to speak out and associate as they see fit. So these were issued in earlier this year. There was a great op-ed, which I'm sorry, I didn't wasn't able to pull up for today, in the New York Times around January, that sort of explained the reasoning. These are on the Keep Our Republic website, along with a lot of resources. And the new news to share is that just this week, the ABA endorsed these principles and resolved that they call on law firms and legal organizations to adopt and support and endorse them. So I think that was a significant step. Wasn't clear exactly what the ABA would do, but it was endorsed by voice vote on the floor, I think on Tuesday of this week. So that's something that's out there. I think it'll be in play going forward. So that's certainly something to think about in terms of how might I get involved. We kind of come back to the formation of Keep Our Republic and the Alliance. When I retired, I sort of reached out and started looking for other folks who had been serving as judges and who now might be able to become more actively involved. And I'll just sort of, as a detour here, there are ethical rules that apply to judges both in state court and federal court that send sort of conflicting messages. On one hand, they encourage judges to speak out in ways that will encourage civic understanding of the legal process and understanding of the role of judges, the rule of law, and judicial independence. On the other hand, there's very explicit admonitions against partisan activity, against commenting on pending cases, against in any way making statements that might be viewed as reflecting a prejudice towards a party. So the rules are, frankly, kind of unclear. And that's something I've just written a law review article on for the Southwestern Law Review, supposed to come out by the end of the month. So I spent a lot of time digging into that, and I'm happy to share maybe in the Q&A period if anyone wants to know more about it. But and for those of you who practice in federal court, there was a federal advisory committee opinion called number 118 issued, I think around February or March, that I think attempted to calm the waters a little bit in this area for federal judges. And I think it did. By nature, a lot of these admonitions need to be, general and have caveats because things that you might in the abstract say are fine. When they're put in a particular context, they may be problematic. So, is it okay to write an op-ed taking a certain position? Yeah, a lot of folks would say yes, depending on the position. Is it okay to be in a march and then go up on stage and stand next to somebody who is giving a very, very strong partisan message about someone else, a political figure who's articulated a particular position? That's more problematic. So by nature, it's somewhat fact bound. So anyway, I think it's important that former judges be willing to stand out, and I think it's important that attorneys be willing to stand up and explain to the public what the rule of law is all about and why it should matter to them in their daily life. So fortunately, I managed to find other former chief justices who were sort of out there in the wilderness, trying to find like-minded people who wanted to sort of band together, and we did. And we announced the formation of the Alliance of Former Chief Justices in, I think it was, let me just see, I don't know if I have a slide about this or not. Yeah, here we go. So we started with 40 plus. We basically had a very sort of general statement of support for the rule of law, although we did stand up very explicitly about judges being vilified for the nature of their rulings. We are nonpartisan. We have equal numbers of folks who came from backgrounds that might be considered to be Republican or Democrat, whether they ran for office, some of them as Republicans or Democrats, say were appointed by Republicans or Democrats. So we're very much a nonpartisan. That's something that's really important to us. Although, to me, I think it is, I find it a bit odd to identify people in that way. But for the public seems to appreciate it when they understand when we have speakers come out and do public panels that, well, there's folks here from both points of view, to the extent that there's a point of view that you might have if you were appointed by a Republican versus a Democrat or ran for office as a Republican or Democrat. But very, very clearly nonpartisan. We're able to speak up when sitting judges can't. And like I said, I think sitting judges should have more freedom to speak. So the two groups, the former federal judges and our group's now up to 59 folks. Federal judges have about 50. We've done a lot of stuff, different things, a lot of op-eds, a lot of interviews. I was on MS Now about 2 weeks ago talking about the role of judges in the context of the SAVE Act. And I guess, what might judges be called upon to do to litigate or to help resolve conflicts that might arise if the SAVE Act, which imposes very strict requirements for folks to register to vote and to actually vote, were enacted, and with the expectation that it would be implemented by November. So I kind of talked about, without expressing an opinion one way or the other, talked a little bit about the role of courts in that situation. We've been out, the former justices have done a lot of community forums at different places across the country. My organization took a position in a rulemaking the Department of Justice had proposed, basically giving itself the first crack at attorney discipline for DOJ attorneys. That's something near and dear to my heart because I used to be an assistant U.S. attorney. And so the first sort of salvo on that front was this rulemaking that basically said DOJ gets to look at any complaints about one of their lawyers first and sort of decide whether it thinks there's merit to it or not. And it was kind of an open-ended sort of grabbing of any of these things, which I think of any of these complaints, which raised the possibility that they might never see the light of day in a state disciplinary system. Just to be clear, lawyers, all federal lawyers, to my knowledge, are licensed by some state somewhere, and are responsible to that state for to adhere to its code of professional responsibility, and are subject to discipline at least by that state or any other state where they're licensed. So these were did a lot of media stuff. We just as I said, I spoke just 2 days ago. The former Kansas chief was out talking about the elections in Kansas. I don't know how many folks knew there was an initiative in Kansas basically to move from a merit-based judicial selection system to a election system that was not really spelled out how it would work. And that was rejected soundly by Kansas voters. My colleague, former Chief Justice Lawton Nuss, spoke out a lot about it, was interviewed on CNN, I think yesterday, CNN International. So a lot of interest in these issues. Let me see what else we've got. And I'll try to, I know I spent a fair amount of time already, so I'll try to. So this was one event that we worked on. We both a year ago in 2025 on Law Day, a number of almost sort of organically this sprang up across the country. Folks came in to reaffirm their oath, lawyers to defend the Constitution. We had that happen here in Hawaii. I think on like 2 days' notice, something was put together at the Supreme Court. We opened our doors and I administered the oath to anyone who wanted to take it. And I think people were very moved because that was right in the middle of some of the most intense issuance of the EO's executive orders, and some real, I think people had started to have real concerns about where the rule of law was headed. So we participated with a group of other organizations to put together another one of these days. And we had, I think, 70 to 75 different sites, including 5 in Hawaii, 1 in each circuit, where people came into courts and had the oath of office administered to those who wished to take it. And I think it was a very important showing of support for the rule of law. And I want to thank acting CJ McKenna, at that time acting CJ McKenna, for her support. Another big thing, and again, I'll sort of accelerate so I can take questions. Really significant. I think it's really interesting because it shows the sort of, if you pitch these things in the right way or explain them in the right way, they really resonate with the public. So one of the members of my group, former Ohio Chief Justice Maureen O'Connor, led a bus tour of former judges to Pennsylvania, Ohio, and into Michigan. I think it was 4 days. And they had, it was a sort of rotating cast of folks. I think they had about a dozen judges on the bus. They would come into a town, they go to a community center, they go to a school, they go to a diner, they go to a college, law school, you name it, and talk to people about, hey, what's the rule of law? Why does it matter to you? And they explained it in ways that I think were very common sense and that people could really relate to. And, it got amazing media coverage. And look, this was us. We had reaffirmed the oath here I mentioned. So this was a story Hawaii News Now covered it. So this is the Justice in Motion bus tour. They had a logo bus, which is kind of cool. And there were other people who were involved. Keep Our Republic was involved. Something called the Democracy Rising Collaborative was involved. The Cleveland Bar Association was involved. An organization called Ohioans for the Rule of Law was involved. I'll get to that in a minute. But basically, it had amazing media coverage. So they had someone from USA Today who rode on the bus, and this was that's the story. One of, I think, maybe 2 stories that the person filed. Front page story in USA Today. I think we were in the Washington Post as well. And let's see. Yeah, there we go. Washington Post, in Cracker Barrels and Town Squares, a group of judges and other civic leaders. God, I feel terrible. I missed that. This week over at Judiciary, they consider under attack. And, if you're able to find, these judges, Justice O'Connor and Justice Donnelly from the former Ohio Supreme Court justices, were just really, really good at explaining why this should matter for people and why they were there and why they felt the need to speak out. And, to me, just the fact that they met with such interest and enthusiasm when it was explained to people and when former judges made the effort to go out and engage directly with folks, that was a really big deal. I think I mentioned, my friend Lawton Nuss. So this was a big initiative on Tuesday. He was interviewed on CNN yesterday after voters rejected this initiative. I think it was basically 60 to 40%, and a lot of background behind it. They have a merit-based selection system for Supreme Court justices. The legislature was very annoyed at some of their rulings, which included finding a right to abortion in the state constitution, which became a very big deal in the wake of Dobbs, funding for schools. And those are the 2 biggest ones. That I think there were maybe voting rights issues as well. And right after Dobbs, I think the folks who opposed having an abortion right in that state put on the ballot a constitutional amendment to basically ban abortion in the state of Kansas. It was rejected. Some of you may remember right around about a month after Dobbs, it was rejected also by about 60-40. And that, I think, a lot of folks, I think, were kind of wow, because, Kansas is a very conservative state. And one of the proponents of that was a person who's now the Kansas Attorney General. And he was quoted maybe a few months later as saying, well, okay, that didn't work, but what we're going to do is we're going to change how we select judges, and we're going to elect judges, and we're going to slowly get the judges we want on the Supreme Court, and they're going to rule the way we think they should rule on this issue of abortion. And it wasn't a particularly smart thing to say, because it was brought out, I think, during this campaign that, you know, the proponent of this is saying this, he's telling you exactly what he wants. The legislature's unhappy. And because of that, they're going to change how judges are selected with this express desire to get a different outcome. So again, Kansans rejected it about 40% to pardon me, 60% to 40%. I know Chief Justice Nuss and others were out there working hard. A few other things, and then I'll throw it open for questions. There's a lot going on nationally, and a lot of work being done on lawsuits. You know, I think the count, the most recent count I saw, and there's different ways of counting, something like 850 lawsuits involving the administration. Lots by state attorney generals, typically blue state attorneys general, not all, but typically. There's a group called Lawyers for Good Government that supported the May 1st events, also has a very vigorous pro bono policy, sort of program, including, I think, work doing court of claims appeals for small businesses and others who came out and had to pay tariffs, and who are going to have a really hard time getting that money back because they don't have the money to buy to hire lawyers. And I think that program actually even exists here in Hawaii. There's a Hawaii business who I believe was represented through that program. ACLU has been doing a lot of cases. NAACP Legal Defense Fund, a group called Democracy Defenders Fund. Some of the big law firms, mostly the four who refused the EO, have done a fair amount of litigation. Jenner and Block, Wilmer Hale, Sussman Godfrey, and I didn't write down the other. I should. I can't believe in that. Oh, Perkins Coop, pardon me. So those folks have been doing a fair amount of pro bono litigation, and so I think all of them are you know, very significant, contributing very significantly. There's also a group of former federal and state judges led by a judge named Michael Ludig, who I believe was on the Fourth Circuit, now retired, Nancy Gertner, who was on the District of Massachusetts bench. You may remember her. She spoke at our Access to Justice conference, I think maybe 3 years ago, who filed a number of amicus briefs, some of which I've joined, including one that related to the, I think in essence, helped to put a hold on the $1.776 billion settlement of claims for potential settlement fund that was going to be used to compensate folks who, in the president's view, had been unfairly targeted. What else? So I think an interesting question is, you know, what can lawyers do? And I'll just share one or two thoughts about that and then throw it open for questions. You know, by all accounts from people I've talked to, and I've engaged a fair amount with people who are active in election matters nationally, it's going to be a rough election season. You know, how rough and in what way, I don't think anyone can predict, but I think generally speaking, some of the president's comments when he went on national TV about 2 weeks ago to talk about issues related to the election, I think some of what he said was read as basically a lot of it related to 2020. But it seemed to be laying the groundwork for sowing seeds of doubt about the 2026 election. At least that's how it was perceived by some folks. So there's going to be a lot going on, a lot of challenges, a lot of doubt, a lot of concern among people who are going to be told over and over again that the system is crooked, it's rigged, can't be trusted, the judges are crooked, can't be trusted, you know, liberal, crazy, Obama judges, however you want to characterize it. So how can lawyers get involved? Well, you know, I mentioned the principles earlier. I think that's one way. Another way, I think, is can lawyers come together in particular jurisdictions to speak out collectively? Because, you know, we all have our individual voices, which may or may not be able to get on the radar of the public in our respective communities. Ordinarily, you would say, hey, what about HSBA? Well, HSBA is a mandatory bar, and because of the Keller decision, it has limits on its ability, because people have to pay dues, there are limits on its ability to engage in what could be characterized as political speech. So HSBA and other mandatory bars are limited in how far they can go. And Kathy, correct me if I got any of it wrong, but I think that's a fair statement. You know, it would, you know, where I sort of first, the light bulb went off for me on this, you know, was I was sort of trying to recreate what had happened after I became part of the alliance. I went back and looked at, well, hey, what did the APA do about all of this? And they had issued a statement in the spring of 2025, which I think pretty strongly took the administration to task on what it saw as challenging the rule of law and took fairly strong positions, but not unreasonable ones, I think, given the facts as they existed at the time. And it was signed by a whole lot of bar associations. When you look at it, unless others signed later, only about 10 statewide bars signed on. So a lot of local bars, and I think the reason for that is because they are voluntary bars. So if you're a member of the, I don't know, Cleveland Bar Association, or I think even our neighbor island bars, you don't have to join them, right, Kathy? No. So this issue of you're compelling my speech, you're compelling me to pay money to subsidize speech I don't like, isn't a factor. But so, okay, what about the states where the state bar is limited in what it can say? Well, one thing that's happened are lawyers in several of those states have come together and organized to form, in some cases, 501c3s, in other cases, just more informally organized groups that advocate for the rule of law. So there's a couple that I can mention. Let me get this up here. I think I am. There. Okay, so one is called Georgia Lawyers for the Rule of Law. If you have a moment, you know, Google it, check out their website. Really impressive presentation of positions in support of the rule of law. This is sort of the opening statement on their webpage. They have 850 members now. Talks about many of the things I've been speaking about earlier, pardon me, and you know, the lawyers who and staunchly defend their right and duty to provide representation without fear of retaliation to anyone who needs it, even those whose cause may be unpopular and in conflict with the position of the government. So a lot of folks have joined that. It's done events, it's done community events. It has a very, very strong communication capability and issue statements and position papers, and I believe engages in interviews to sort of explain to the public why some of the issues that have come up are problematic. There's another one in Ohio, which I mentioned earlier, called Ohioans for the Rule of Law. Sort of talks about the same kinds of things. And says, hey, you know, Ohio, we're not immune. And my understanding of the Ohioans group is that it includes folks other than lawyers, in addition to lawyers. And notably, Ohioans for the Rule of Law was involved in organizing that bus tour that I mentioned earlier. So, you know, pulling something like that off is a whole heck of a lot of work. I mean, you're literally like driving around with a whole bunch of judges in a bus, and then you like pull into a Cracker Barrel, and I guess, you know, ideally there'll be some people in the Cracker Barrel, so I guess, you know, someone has to have gone into that community and said, hey, at 1 o'clock there's going to be judges in the Cracker Barrel or wherever, you know, I don't know, or at the school or at the community center. And so it took a lot of work. These folks were involved, the Cleveland Bar was involved, which I think raises the question of, you know, again, to what extent, if we had a Honolulu bar, might that be able to be involved? And I think, you know, one question is, should we have a group like this here? And that's something that would take a lot of work. People would have to be committed, but, you know, others have blazed the trail, so there's a model to follow. Raising public awareness, I think, would be the other thing I'd mention before I open up for questions. And you know, there's some speakers who are going to be coming here this, I guess, early next year. Martha Minow, who's a former dean of Harvard Law School, is going to be here in January. I'm sure she'll talk about some of these issues. You know, again, I've been talking to people who are involved either at UH or the Davis Democracy Initiative at Punahou, the Better Tomorrow Speaker Series, just to see is there someone else, are there other people we could get in who might help folks here understand just how pressing some of these challenges are, especially with regard to the vote? Because I think I think folks here don't, haven't focused on the nature of what might happen, and even if some of the stuff on the ground that's happening on the continent doesn't happen here, how it can affect what's going to take place during the election and the future of our government. So that's something else that's out there. So I'll throw those out as suggestions, but I mean, I am open to any ideas, and I'm not certainly, what I said is I'm subject to challenge and debate, and you could go farther. It's interesting. How far do you go when you're saying, what is a challenge to the rule of law? And you're gonna, at some point, you're gonna lose some folks who view themselves as conservative, depending on how far you go. But then folks on the other perspective are gonna say, hey, how come we're not speaking out about this? And so those are, interesting challenges that folks have to work through. And that's one of the, I think, issues as you get into this area or space. You have to think through and figure out what the right mix is for whatever organization you're trying to beat me to it. So anyway, feel free, merectenwald@gmail.com to reach out to me, and I look forward to trying to answer your questions. Sorry I went so long.
We can open up some questions to the floor, and then those on Zoom, there is a Q&A function. Please submit your questions there. But yeah, let's open up to the floor for any questions. Any questions here on the floor?
Sure. There you go. Yeah.
Well, no, I was thinking about my.
Oh, you can have a question.
Yeah. Any?
Yeah, Tyler.
So the Supreme Court, US Supreme Court seems to have taken most restrictions off the redistricting process, the gerrymandering. Do you have any comments on the Supreme Court decisions? And it seems a lot of allegations that Supreme Court decision is by definition the rule of law, but then a lot of people say that it's controlled by politics. So, politics has a way of infiltrating itself into the laws that make up the rule of law.
Yeah, I think that's actually always the debate, and that's a challenge to merit-based selection systems as well. Folks say, well, those judges are just as partisan as anyone else. I personally feel that merit-based systems are less subject to folks coming in who are just there for partisan reasons. I mean, I have personal views about the Supreme Court's decisions. I mean, I think the Calais decision is, in my personal view, is wrong, and wrong-headed. It takes a wrong-headed, in my own personal opinion, view of the purpose of the Civil Rights Acts and the purpose of the Voting Rights Act, and why it's important to have the various safeguards that were in place that first were eliminated by Shelby County and now by Calais. So I think but that's just a personal view. But I think, what the risk is that, folks are going to slowly begin to lose confidence in elections. And I think that was, certainly as I listened to the president and turned on his speech. I think everyone probably remembers, it was 2 weeks ago. It was national. It was a national speech on, primetime TV at 9 o'clock, and talked a lot about 2020, but, also talked about it in a way that might lead a reasonable person who doesn't really have much understanding one way or the other to think, hey, the whole thing's crooked, can't trust it, and that's a really bad position for our government to be in, our democracy. So that's why I think folks who Keep Our Republic, who've been out there doing the really slow, heavy work in these different states across the country, to try to have people understand and to, if nothing else, humanize their local election officials has been really important.
All right, looks like we have a question on Zoom. Let's see here. President Trump has taken executive action in areas reserved to congressional authority, like attacks on elections by mail, for example. Today, President Trump issued 2 executive orders that on their face seem to threaten the third branch of our government. and specifically the authority of the US Supreme Court. The president signed executive orders that target children born to alien enemies, foreign lobbyists, or terrorists. Do you foresee President Trump will begin to thumb his nose at, sorry, I can't read that,
no, rulings of the Supreme
rulings of the
Court.
Supreme Court
Yeah. So,
that curtail or invalidate his edicts and executive orders. Sorry.
no, I hadn't seen this morning's EOs. I was prepping to come here. Always should check the newspaper to make sure you understand what's coming. I mean, I think the president has blown hot and cold on, adhering to judicial rulings. Early on, he said things that, probably, late spring of last year. He was interviewed, like, do you think you have to follow, rulings of the courts? Sort of something like, I don't know. Certainly folks in his administration have sort of laid the groundwork for the suggestion that there might be rulings that don't have to be complied with. But yet other people have sort of talked about, of course we're gonna follow what the Supreme Court says, maybe a little less deference to the trial court. So I honestly can't purport to get inside the president's head, and I'm not sure where he's going, other than, if you've worked through the scenarios for this fall, I mean, there are a lot of potential actions that could happen that could be very disruptive to the voting process. If, for example, ICE agents were deployed to cities where perhaps there are a lot of population of folks who might fear some form of consequence for their own immigration status, might stay away from the polls. Other people might just stay away from the polls because they don't want to be caught in the middle of some kind of crossfire. So, there's a whole lot of voter suppression that could take place going in. And then frankly, on the other end, you could simply have people who are holding office say, I'm not leaving my office. I'm not leaving. This was an unfair election and I'm not going to go. So, I don't know what the plan is. I don't know what's coming. But, when you look back in the last month or so, there've been an awful lot of developments that I think are, kind of problematic. There's sort of a demand letter to all the election officials across the country, including ours, Scott Nago, that said, you need to comply or, we'll be investigating, which I think, it was kind of ambiguous, but sort of a reminder of the potential, and I think it actually referred to potential criminal liability. The FBI was sent into Fulton County, Georgia. Something like 250 agents were assigned to review voting records from there. Issues related to mail-in voting and trying to basically make it more difficult for folks to vote. We're still being pursued by the administration, despite I think now being up to like 0 for 18 in court decisions. So a lot going on that I think causes I think impartial observers to be worried about what it's going to look like. So all the more reason to have courts that are trusted, that have the faith and confidence of the folks who are going to be affected by their decisions. Because frankly, if we don't have that, it's not clear to me how these issues will be resolved in a manner other than just by brute force.
Any other questions in the audience?
I hesitate to ask this, and I apologize if it puts you in an awkward position, but do you have anything that you'd like to share about the Hawaii Supreme Court opinion about the US Supreme Court? I think that was Renello recently highly critical of the US Supreme Court being political.
I haven't commented on it one way or the other. I think it's kind of untoward for me, especially after having just been on that court that recently, to sort of comment on a decision that frankly I don't understand the underlying facts about. But if nothing else, it's sparked debate across the country. Some folks who are think it absolutely had to be said, other folks who think it was out of line to be said. And I think you know, again, having that kind of discussion and debate, I think is ultimately healthy. But in terms of the merits, in terms of the actual, you know, issues that were written about, I can't really express an opinion, at least not that I'm comfortable doing.
Thank you.
All right, we got another question on Zoom. Won't your proposed use of local bars exclude minority opinion lawyers from being represented in their local bar? They will have to vote with their feet. I think I'm reading that right.
Yeah, you know, I, in a sense, I mean, folks, and I think everybody who works in this area has to understand, you know, have to make judgments about how aggressive are they going to be in terms of their positions. Do you value having a bar that has a wide range of views, including folks who are very solidly conservative or very solidly President Trump supporters, and are you willing to soften your views to sort of pull back to the sort of the core issues that I talked about early? And or do you want to head out and be a little bit more aggressive? So you know, certainly, you know, if there's a thought that, you know, it's problematic to have a organization that's affiliated with HSBA because it's a local bar involved in that way, then certainly it can't be an issue if an organization springs up on its own, like Georgia Lawyers for the Rule of Law. And because no one's forced to be a member, there are other alternatives for folks who want to participate in the debate. And I think that's the sort of the attraction of those types of organizations. And, you know, I think they're about, those two that I mentioned are the strongest ones. There are others that I think are sort of coming into focus. But again, it's, you know, as a lawyer who wants to get involved and have a collective voice, how do you do it? And I think there's a choice that the organization has to make about how inclusive does it want to be versus how aggressive does it want to be.
And then we'll probably take one more question on Zoom just to be respectful of everyone's time. But is it okay if they email your questions?
Oh, for sure.
Yeah.
Yeah.
Okay, so last question is they say the sole purpose of our US Constitution is to protect individual rights. Do you agree?
Oh, well, it does a lot of things. I mean, it establishes the structure of our government. It establishes separation of powers. It establishes principles of federalism, and, you know, the Bill of Rights, of course, supports and protects individual rights. So, you know, it has, and frankly, you know, some of the things, the more structural issues that I raised early or mentioned, like federalism, you know, really do affect issues of what people's individual rights are. And of course, you know, we have the doctrine or the principle of state constitutionalism, which is states have the ability to provide greater protections to their citizens than the US Constitution provides, as long as they don't conflict with the US Constitution, which is kind of a big caveat. But so I think that it's not the only subject. I mean, it's obviously a critical subject, and of course, it was actually the Bill of Rights. The Bill of Rights was an amendment that came in after the original document, if I recall my history correct. So, anyway, but I'm happy to answer more questions, and hope this has been helpful. And really appreciate your interest, appreciate your time, and you know, lots of interesting things to be considering and thinking about going forward this fall.
Awesome. And then for those on Zoom, yeah, sorry, we would like to apologize if we didn't get to your questions, but feel free to email CJ well on the on your screen using that email address. And Greg, you want to give us closing remarks?
Well, yes, but not really. I just want to thank Chief Justice Mark Recktenwald for taking the time to bring us up to speed on the work that he's done to help save our country. Thank you very much.
Thank you very much.
Thank you, everyone.
We're going to pick this up, so I had to come and give